The difference between a reportable and a non-reportable judgment of the court. एक reportable और non-reportable judgment में क्या फ़र्क होता है, यह जानना चाहा है हमारे ही चैनल के एक दर्शक है। उनका क्या नाम है वो मैं वीडियो के आखिर में शाउट आउट देकर बताऊंगा। The topic of today's video is this, and I'll be speaking in both languages, English and Hindi. That is because this video is for both general people as well as for young advocates. And dear friends, please excuse me, I will not be speaking in either of the languages completely because अगर मैं हिंदी में बात करता हूँ तो मेरे इंग्लिश स्पीकिंग दोस्त कहते हैं कि सर प्लीज़ स्पीक मोर इंग्लिश, और जब मैं इंग्लिश में बात करता हूँ तो मेरे हिंदी स्पीकिंग दोस्त कहते हैं कि सर प्लीज़ एक्सप्लेन इन हिंदी. So what should I do? I thought this midway should serve the purpose of both the groups. Okay, so coming back to the topic. When we think of a reportable judgment or a non-reportable judgment, पहला सवाल हमारे मन में आता है या आना चाहिए कि where? Reportable where? In the newspaper? Or in some magazine? Or on website? Or where? तो यहाँ जो रिपोर्टेबल या नॉन रिपोर्टेबल की बात की जा रही है वो है लॉ जर्नल्स में. इट इज़ अबाउट रिपोर्टिंग इट इन एंड पब्लिशिंग इट इन द लॉ जर्नल्स विच आर पब्लिश्ड बाय पॉपुलर एंड फेमस पब्लिशिंग हाउसेस. सो द क्वेश्चन इज व्हाई सम पब्लिशिंग हाउसेस, famous publishing houses like Supreme Court cases or All India Reporter or Maharashtra Law Journal in Maharashtra, or say Maharashtra, All Maharashtra Reporter. Why do these publishing houses report and publish judgments of high courts and Supreme Courts in the first place? ऐसी क्या बात होती है कि ये लोग सुप्रीम कोर्ट और हाई कोर्ट ने दिए हुए जजमेंट्स को अपने रिपोर्ट्स में, अपने जर्नल्स में पब्लिश करते हैं? Why? Understanding that is very important. See, what is a judgment after all? Judgment, either of the Supreme Court or that of the High Court, are after all adjudication of disputes. It's a decision of the court. It's a judgment between two parties resolving their disputes. ठीक है? If this is so, then what is so great about it? Why should it be published in the journal? Now, to make things very simpler, let me tell you that whenever a court, I mean higher court, I'm not talking of lower courts here, I am talking of High Court and Supreme Court. So whenever these superior courts deliver some judgments, they not only decide the dispute between the two parties, but also do something else, something more, which is beneficial to the whole world. And what that thing is, they interpret some law, or they may deduce some new legal principle out of the facts that are there before them for adjudication of the dispute. मतलब जजेस केवल दो पार्टी के बीच का झगड़ा समाप्त करने के लिए एक निर्णय देते हैं, यहीं तक उनका कार्य सीमित नहीं होता. कभी कभी ऐसी सिचुएशन आती है, ऐसे फैक्ट्स आते हैं जिसमें न्यायालय उनके सामने जो परिस्थिति है उसमें से कोई लीगल प्रिंसिपल भी डिड्यूस करते हैं या कोई प्रोविज़न इंटरप्रेट करते हैं. तो वो केस में जो पार्टीज़ इन्वॉल्व होती है उनके अलावा ये जो डिड्यूस किया हुआ लीगल प्रिंसिपल है or the interpretation that binds the rest of the world. Here, when I use the word world, I mean India. We are now in India, so I am talking about India. So in addition to the parties that are there in the case, there are certain things in the judgment which bind the rest of the people even when they are not parties to the case. Why this is so? This is because of a principle called doctrine of precedent. Now this must be new for you. Doctrine of precedent का मतलब सिंपल है, एक ऐसा तत्व जिसके वजह से ये माना जाता है कि जो भी रूल या इंटरप्रिटेशन हायर कोर्ट्स अपने जजमेंट्स में ले डाउन करते हैं वो भविष्य में आने वाले सिमिलर परिस्थिति को लागू करना बाध्य होगा। ये कंफ्यूज होने की बात नहीं है। प्रीसीडेंट, डॉक्ट्रिन मीन्स से प्रिंसिपल। प्रीसीडेंट इस शब्द का मतलब जब आप समझोगे तो सभी बातें समझना इजी होंगी। प्रीसीडेंट ये प्रेसिडेंट नहीं है, अध्यक्ष वो नहीं है। आई एम सेइंग प्रीसीडेंट, PRECEDENT। ये शब्द आया है प्रीसीड ये शब्द से, PRECEDE। प्रीसीड मतलब पहले आने वाला, भूतकाल में जो हो चुका है वह। तो भूतकाल में यानी इन द पास्ट, इफ a particular situation has given rise to a particular interpretation or it has resulted in deduction of some new legal principle, why not take advantage of that in a similar set of situation which may arise in future? The wisdom lies in that. And therefore, the principle deduced in one set of circumstances become binding on the courts whenever a similar situation arises in future. So all the lower courts are bound by the legal principle deduced in that judgment and the interpretation made in that judgment of some particular provision. And they have to decide the future cases on the basis of that legal principle or that interpretation. Interesting, na? Okay, let's move ahead. So this bindingness actually attributes to the judgment of the Supreme Court and the High Court what we call law quality. The judgments themselves become law of the land. I mean those judgments which are of that quality which I said. Those judgments which actually interpret some legal provision or lays down some new rule or deduces some new rule. Those become binding as law of the land. Now, I do not know whether you all know or not, but let me tell you, there are three sources of law in the country, mainly three sources: custom, legislation, and precedent, that we have learned in law colleges, and that is there in the jurisprudence also. Custom should be very old, aged custom. It should be practiced from antiquity, and this and that and so many things that are there that should be there for a custom to be binding as a law. Now you know all legislation, the acts passed by parliament or the acts passed by the state legislatures, they are in the form of legislation, or the rules made under those acts, they are also delegated legislation. So that all goes in the area of legislation. And third is precedent, that is this judge-made law. Yes, this is popularly called judge-made law or case law. All these precedents are judgments called case law or judge-made law. Now this practice we have adopted from Britishers because we fall in that family of law called common law. The legal system of Britishers is based on common law, and common law is all judge-made law. Judge-made law, I mean. And in all those countries which were sometime in the past governed by Britishers, they all fall in this family called common law countries, where there is a prevalence of judge-made law. I mean the case laws also become the laws of the land. अब बात चल ही रही है तो मैं तुम्हें एक दो और इम्पॉर्टेंट फ्रेजेस से फेमिलियर कर दूं. फर्स्ट इज रेशियो डेसिडेंडी एंड द अदर इज ऑबिटर डिक्टा. नॉट डिफिकल्ट टू अंडरस्टैंड, जस्ट बेयर विथ मी. रेशियो डेसिडेंडी मीन्स द लीगल रीजन ऑफ द डिसीजन. मतलब वही बात जो मैंने कहा था, deducing any new legal principle out of the facts of the case or interpreting some provision. That's the ratio of the decision. That's the legal reason of the decision. I'm not saying reason of the decision, legal reason. I mean, try to understand the difference. when the judgment is based upon some legal principle which is deduced in that judgment itself for the first time by the court, that becomes ratio decidendi. And maybe sometimes it happens that while deciding a particular case, the judges, in their flow of dictating the judgment, even when it is not really necessary to do so, do make certain additional observations about law. Those additional observations are really not necessary for deciding the disputes in the judgment, but still they do make those observations, and that is called obiter dicta. Obiter dicta is something that is said by the court in the flow of the judgment, somewhat related to the case but not actually the basis of that judgment. So a judgment which acquires law quality contains two parts, sometimes contains two parts, the ratio decidendi and the obiter dicta. Now what is binding on future courts is ratio decidendi and not obiter dicta. Now it may so happen that obiter dicta of a particular case may get developed into a ratio decidendi in some other future case. But till then, obiter dicta is not strictly binding. It may only be helpful in convincing the future court that this view is also possible, and therefore please take that view and settle it as ratio decidendi. है ना, मज़ेदार है ना? That may happen. So with that, let me also tell you one more important thing. In the Constitution of India, Article 141 of the Constitution of India clearly says that the law declared by the Supreme Court shall be binding on all courts and tribunals throughout the India. Now mark the words, law declared by the Supreme Court. Of course, that doesn't mean that the law declared by the High Court shall not be binding. It will be, because we are still governed by the doctrine of precedent. So even if the provision of Article 141 is not specifically about High Courts, still the judgments delivered by the High Court also acquire law quality. So the law declared by the Supreme Court means that it is possible that the Supreme Court may, in some judgments, declare what shall be the law of the land. And this article, therefore, specifically gives a special place to the doctrine of precedent in our constitution. यहाँ तक बात समझ में आई? इसके अलावा आपने देखा होगा कि कई बार सुप्रीम कोर्ट अपने जजमेंट्स में कुछ स्कीम्स ले डाउन करती है. मतलब sometimes there is no law made by parliament governing a particular field, but the situation demands that there must be a legal framework. तो सुप्रीम कोर्ट ने कुछ केसेस में, इम्पॉर्टेंट केसेस में ये किया हुआ है. फॉर एग्जाम्पल विशाखा केस, द फेमस केस. विशाखा केस में सुप्रीम कोर्ट ने सेक्सुअल हरासमेंट ऑफ वुमेन एट वर्क प्लेस, इसको लेकर एक डिटेल फ्रेमवर्क, लीगल फ्रेमवर्क तैयार करके जजमेंट में ही दिया था. लेटर इन 2013 पार्लियामेंट एनैक्टेड अ सेपरेट लॉ. I think its name is Prevention of Sexual Harassment of Women at Workplace Act 2013. So based on that judgment, later on, the Parliament also took step to convert that into an act of Parliament. Same is the case with Madhuri Patil's case, that is related to caste validity certificates. So that is how the Supreme Court also makes some schemes, and that becomes binding as law. Now coming back to the answer to the question asked by our viewer. Now let me disclose the name of that viewer. His name is Dr. Prashant Pawar. And I thank him heartily for asking this question, because this question is really very important from the viewpoint of general people as well as from the viewpoint of young advocates. So having understood all these things, आपको अब ये बात स्पष्ट हो गई होगी कि those judgments which acquire law quality become useful for future generation or future use of the courts, and therefore they become reportable judgments. Reportable in the law journals, in the law reports, which are published by the law journal publishing houses. and are available for use not only for lawyers but also for general people. The law libraries of many bar associations and many good lawyers are filled with such law reports. आप देखते होंगे ना, वकील के ऑफिस में जब आप जाते हैं तो एक टिपिकल टाइप की किताब होती है जो लेदर बाइंडिंग करके उसमें फिर गोल्डन लेटर्स लिखे होते हैं, पट्टियाँ होती है, एक टिपिकल काइंड ऑफ बाइंडिंग। वो मतलब पहचान होती है कि एक लॉयर के ऑफिस में हम आ गए। Those bound books are of law reports which that particular lawyer has been subscribing since years together and has been collecting in his library. Those then become available to him for ready reference whenever a case of that kind arises. So who decides whether a judgment is reportable or not reportable? Normally, it happens that after delivery of the important judgment, the judges themselves, in the special form, in a separate form that is attached with that judgment, clarify whether this judgment is reportable in law journals or whether it is not. Based on that, then the judgment is sent by the registry for reporting to those law publishing houses. But that doesn't mean that if a judgment is not marked as reportable by a particular judge or any judge, cannot be reported at all. It is not so. Even if a judgment is not marked as reportable by a judge or by judges, but if it involves, it contains the law quality, if it contains ratio decidendi, it can still be reported. I have done that many times. Whenever I came across important judgments delivered by the court in my cases, I have on my own sent those judgments to the law reports, to the editors of law reports, with a request to consider it for publishing in their journal, and then I have in response received letters from them thanking me for bringing to their notice that important judgment, and they reported that the judgment would be published in such and such volume of that particular report. So that is how the judgments become reported, and some judgments do not get reported. The judgments sometimes give an impression that they contain various legal provisions and they are really important, but when read in depth, they do not at all contain any ratio decidendi or even an obiter dicta, although it refers to few past judgments. Merely referring to the few past judgments wouldn't make a particular judgment a reportable judgment, right? Things have to be seen minutely. The whole judgment has to be read to understand whether it really contains a ratio decidendi that will be binding on the courts which would decide future cases. Now friends, with regard to this doctrine of precedent, there are many things that can be shared with you. But since the length of the video would go very long, I am not sharing them here. I would share them in some other video. Those things are, suppose if there are 2 or more judgments on the same point, then which one to be preferred? Then there are principles governing this. Larger bench is to be preferred to the lesser number of judges. Latest judgment is to be preferred to the oldest one. And things like that. There are many other criteria for deciding all that. Before I take leave, I welcome all the new subscribers to the channel. And now we are a family of 42,000 plus. And I hope you are learning so many things from this channel. You are also enjoying this knowledge and information. Thank you for watching. Take care and bye.